have the privilege of welcoming you this morning and introducing this session. Just a couple of housekeeping announcements. Please remember to fill out and turn in your yellow CLE certification form before you leave today. You will need to turn that in to receive your CLE credits. We also wanted to thank our vendors for joining us today. Please take some time to visit with them in between sessions. And we also wanted to do a special thank you to Jim Schlee from Canon Business Solutions. He will be presenting the next hour on business challenges facing your legal practice, so go ahead and check them out and visit him in the hallway as well. As a special treat today, our family wizard is here today, and they are also at a lunch in the Studebaker room. If you would like to learn more about them, their parenting time app, have a wrap and sandwich, stop by their booth and let them know that you will be coming to this lunch and learn. We appreciate Giuseppe from Ohio with My Family Wizard coming today. It's a great opportunity to learn more about the app and how it can help your clients. As a courtesy to the speakers today, please silence your phones. The Wi-Fi information is being passed around, but if you need to go onto your laptop, it's Hilton Honors, and then select I have a promotional code, and the Wi-Fi password is SBN standard, just like the airport, capital S. We are here for Bankruptcy Basics for non-bankruptcy attorneys. Before we get started, I wanted to give a special thank you to Judge Singleton's law clerks, Brian Ortiz and Philip Martin, for all their help in getting this organized, and Judge Singleton and Katherine as well. Judge Paul Singleton has served as the bankruptcy judge for the United States District Court for the Northern District of Indiana since July of 2021. He previously served as magistrate judge for the St. Joseph Superior Court. Prior to becoming a judge, he served in various roles in St. Joseph County, including with Indiana Legal Services, Assistant City Attorney for the City of South Bend, and at the Family Justice Center. Katherine Iskin is a partner at May Oberfeld Lorber and focuses her practice on banking and creditors' rights, both in and out of bankruptcy, as well as employee benefits, including ERISA. Prior to joining May Oberfeld Lorber, Katherine served as a staff attorney to the Chapter 13 trustee for the Northern District of Indiana. She has taught bankruptcy law as an adjunct professor at Notre Dame Law School and serves as chair of the ISBA's Bankruptcy and Creditors' Rights Committee. And even though Katherine is an Ohio State Buckeye, please still give her your undivided attention. Without further ado, Judge Singleton and Katherine Iskin.
Before we get started, does everybody have yellow and green cards? We're going to make you participate for your CLE credit. All right. All right, so welcome to Bankruptcy for the Non-Bankruptcy Attorney. There aren't audience microphones, but if anybody has questions, please feel free to step up. Ask questions, participate. This is hopefully a fairly discussion-based session rather than just a talking session. All right.
With that said, let's go ahead and tell you what we're going to be learning about today.
Hopefully once we...
What'd you do? You want to try?
Okay.
All right, so the objectives you can see there: debunk bankruptcy myths, explain some key terms, and explain how bankruptcy cases may or may not affect your cases, family law cases, personal injury cases, and maybe even child support cases. Green will be for true, yellow will be for false. We will begin with the first video. Take it away.
This is State v. Kermit T. Frog, 99D012504F51234. State your name, please, for the record.
Hi ho, this is me, Kermit the Frog.
I am going to tell you what you are charged with, Mr. Frog. and advise you of your rights. You are charged with a level 5 felony, and if convicted, would be looking at anywhere from 1 to 6 years in prison. You have a right to be represented by counsel.
With all due respect, Your Honor, I'm going to stop you right there. I don't think we've had the pleasure of meeting, but I am that guy. We must stop these proceedings because my client has filed a bankruptcy petition, and there's this thing called the automatic stay. All right, so true or false? The automatic stay stops criminal prosecutions. All right, yeah, we've got a lot of yellows, no greens. And then I'm actually probably going to pick on Katherine a bit because I think that she, as a former Chapter 13 trustee and now advising clients in bankruptcy cases, I think she gets a lot of interesting questions. So I'm going to ask her some questions throughout this presentation. You can feel free to do the same. So automatic stay, key principle of bankruptcy law, definitely doesn't apply to criminal prosecutions. Katherine.
So this is almost universal. Anything criminal, bankruptcy doesn't really touch. There's some like weird SEC violation things that kind of bleed in, but that is not for a bankruptcy basics course. But for the most part, anything criminal, bankruptcy doesn't touch. So who's protected by the automatic stay? Every single debtor, as well as all the debtors we call property of the estate. So property of the estate is a very, very broad concept. It's not just what you would think of as like somebody's property, but the rights that they have when they file for bankruptcy and rights for things that they don't even know they have for 180 days. So if somebody files for bankruptcy and their wealthy aunt passes away 170 days later, that inheritance that didn't even exist 170 days in the past is now property of the estate. And some co-debtors in the double-digit cases are protected, but sometimes not. Again, that's not really a basics thing. And this does apply to both individuals as well as businesses. So there's sometimes when businesses and individuals are treated differently, but not as far as the automatic stay goes.
And you mentioned the double-digit cases, and I do see some familiar faces. Can someone just help me, give me a brief reminder, 7, 11s, you can talk about 12s if you want. We don't have many of those here, 13s. So 7s, remind me of what Chapter 7 is.
So a Chapter 7 is what we call a liquidation. That's what most people file when they file for 7 overwhelmingly. They file, about 90 days later they get a discharge. Typically there's nothing for a trustee to collect and distribute to creditors. For individuals, it's usually a 13. But all the double-digit cases are reorganization cases. And those last 3 to 5 years. 11s are a little bit different. But those are reorganizations rather than just straight up filing and walking away.
And for some of you, I know who may have had a bigger bankruptcy practice and maybe you no longer do, it's fairly recent. In 2020, if you did any sort of subchapter 11s before that, or chapter 11s, and now you don't do bankruptcy anymore. In the Northern District of Indiana, actually all the cases that we've had this year in the South Bend Division that have been Chapter 11 cases have all been subchapter 5 cases. It's supposed to be a quicker, more efficient, and cheaper way for businesses to have a Chapter 11 case without maybe having as many of the expenses. So subchapter 5, special type of Chapter 11 case.
Yeah, for small businesses, it's not for your GMs of the world, it's for your kind of local mom and pop shops. All right. The automatic stay is an injunction against any collection activity against a debtor or their property. So, and it's not something that the debtor has to file or ask for. They file it and it's automatic. It kind of springs into existence as a function of the law. So it's an immediate injunction against collection activity of all kinds against the debtor or their property. That means garnishments have to stop, except for certain kinds of child support. Any kind of foreclosure, eviction, anything has to halt immediately. Right, garnishment, foreclosure, repossession. Those are your big ones.
All right, so we've done the who, we've done what is the automatic stay, it's injunctive relief, when does it apply? So in general, for the most part, it's going to apply, and I think this is kind of odd, but immediately once the petition is filed, that injunctive relief is going to be effective. And we have an asterisk there, so there are some exceptions, and that's going to be if a debtor, I say, goes to the well too many times too quickly, then the automatic stay may not be in place. It may not be effective. So if you are a creditor and you are not sure whether the automatic stay applies, what are maybe some of your options?
Typically, you would file what we call a motion for relief from the automatic stay, and that way you can get a order. And even if it is something that you believe the automatic stay doesn't necessarily apply to, but the debtor is raising it as in state court, you can still file a motion for relief to get a comfort order. So that's how you would kind of circumvent that if there are kind of exigent circumstances. So if the debtor's like squatting in foreclosed property and they're damaging it while they're there, you can then file a motion for relief to kind of enter before that time would kind of pass in the case.
And maybe, can I maybe pick on some of the practitioner or even some of the judges? When I was in state court, the way that I knew there was let's say it's a collection case, small claims case, and state court judge is super busy, you're looking through a bunch of cases, there would be a little flag in the electronic system that would say, hey, Singleton, there is a bankruptcy case. You may want to be careful before you enter a final garnishment order or allow interrogatories to be issued. For the practitioners, what does it look like? Do you get any sort of notice, or do you just have to read the docket? George made eye contact.
When we file a bankruptcy, if you know there's a case in Circuit or Superior or anywhere. Oh.
Sorry, do you mind repeating that just so?
When we file a case, if we know that there's a pending collection case or litigation, we're supposed to notify the clerk of the court in that case, so then it's public record. So I think that's how we would know.
But when you go pull up the case on Odyssey, there's not any sort of special highlight or flag that says a notice of a bankruptcy petition has been filed. Proceed with caution.
Unless the clerk files your notice. I assume if the clerk files your notice like they would file a pleading, then it would show on Odyssey. I have not checked that to see if that's the case. But
I think it also would have to be in whatever case it was that it's connected to. Like I have a client who...
I can use that. Do you mind just so...
Yeah, I have a client who on the other...
I have a client who we are against the other person. They have a bankruptcy pending, but it doesn't affect the case that we are necessarily handling. And so our case goes forward, but that person might have a foreclosure or other debt that is being stayed in regards to something else. But what I have going on with that person had never filed a motion for an automatic stay in our case, wanted to continue to still proceed forward. So I think it would have to be in each of the different cases. That person who's filing for the bankruptcy would have to put it into each one I would not know that he had a bankruptcy unless I was told.
The only time that I've received a notice is if we're in the post-judgment collection phase, and then we're a creditor, right? So then we get notice as a creditor. But that's the only time that I've actually received notice is post-judgment collections.
Well, I feel like you can get it, sorry. You can get it pre-judgment, like if you're going to show up to like get possession or like, get a judgment, but they usually, like the debtor or the person would usually show up with their notice at the court hearing and be like, hey, I filed bankruptcy. 9 times out of 10, when I used to do collections or even now when I do evictions, a lot of people threaten bankruptcy. Like, if you do this, I'm just going to file bankruptcy. I'm like, okay, once you file bankruptcy, let us know immediately. And then, but we don't stop moving until we actually get the notice. There's not like a flag that pops up on Odyssey from what you're asking. But if they file it, then obviously as the attorneys of record, we'll get notice through the filing. And then we kind of just note it in our own notes that like, hey, we've gotten notice of a bankruptcy. And obviously you guys have gotten notice of a bankruptcy on the judge's side too. So.
Judge, do you know if in the judge's version of Odyssey, is there like a...
So there will be a flag that will show if a case has been stayed. It's not something you see often. Most of the time, and the creditor's counsel isn't looking to violate the automatic stay provision, so there's generally not a filing you would see after the stay is in effect. Oftentimes what I see from good creditors' attorneys is once the stay is in effect and they have a garnishment, you'll get a release of garnishment and things of that nature. So it's not something we see often, but it exists.
Okay, next slide.
So where does it apply? I kind of already touched on this. It applies to all of debtors' property, wherever it's located. If they have a timeshare in Aruba, it doesn't matter whether it's in the United States. Their right belongs to them in the United States. The same goes with real estate in other states. And it also applies to common law property if they've lived in any common law states before Indiana. Wisconsin, I think, is the only one that we've really run into locally. So why, like from a conceptual level, why does the automatic stay apply? From the debtor side, it provides the debtor with a fresh start, so it kind of wipes all of their debts clean for the most part. And it gives them breathing room where they're not being contacted by creditors, garnished, called, sent letters, whatever. On the creditor side, it also gives everyone kind of a centralized point to put everyone's debts and everyone's assets in the same pot and to kind of get in line. So it's much more orderly than just which creditor gets a judgment lien first and like, can they go and execute on this quickly? So that's also why the automatic stay applies, is to give the bankruptcy court a chance to review the case and to administer an orderly kind of dissolution of the property.
All right. You represent the supplier, and doggone it, just sick and tired of dealing with that customer that doesn't pay. And so a commonly used tool, I guess this is the question, right? So a commonly used tool for that supplier is to say, I'm going to put an involuntary bankruptcy petition on you. You've heard that in your practice?
Yeah,
Katherine?
it does kind of happen with small businesses. So-and-so's threatening to file an involuntary on me. So raise your cards green for true, yellow for false, that this is a commonly used tool.
See a lot of yellows.
Yeah, this is false. Involuntary bankruptcies are very, very dangerous from the creditor's point. It is a thing that creditors do to force a debtor into bankruptcy. You have to have like so many petitioning creditors. If you do it and it goes bad, they can get their attorney's fees against you. There's also sometimes things you don't know about, like a trustee might then turn around and do a collections activity against the petitioning creditor. So I have, in my entire career, I've seen one situation where this was appropriate, and even then, there was just one creditor and there weren't enough to kind of get the ball rolling. So it's like I've seen one once. I don't know, Judge Singleton may have seen a few, but.
Yeah, and just for numbers, so roughly of the 6,000 cases that are pending in all three divisions, Fort Wayne, South Bend, and Hammond, there's about 5, it looks like there's about 5 active involuntary cases. So very, very rare.
True or false? Most debtors consider their case a success when their debts are discharged.
See some greens and some yellows.
I think it's true. Most debtors probably yes. A discharge is when the debt is, so to kind of circle back, debt doesn't go away because of a bankruptcy. So it's not the same as a write-off. It is tax neutral. There's just a collection injunction. It's called the discharge injunction that's put into place against collection activity. So that's what we call when the bankruptcy is over and the debts are no longer collectible as it's discharged. Debtors always confuse discharge and dismissal. Well, my case is dismissed. Well, that's a bad thing. So that's not great. There are some cases that don't get discharges that can be successes, like if they rehabilitate a mortgage, but the case fails afterwards. Those are kind of one-offs. But for the most part, discharge is what makes a individual's case successful.
All right, next hypo. Father owes $5,000 in child support. Father files Chapter 7 petition to get his child support debts discharged. Father will be successful in discharging this debt. True or false? Okay. Right, so that's not going to happen, right? Child support's one of the, or I should say, I should probably be specific, a domestic support order is something that cannot be discharged in bankruptcy. And maybe just for a little bit of inside baseball, as a Chapter 13 trustee, can you sort of explain how that process maybe works when someone is maybe not a Chapter 7 petitioner, but a Chapter 13 petitioner, so they're going to pay their debts over a period of 3 to 5 years, and they have child support. What does that look like?
So on the administration side, not only can they not discharge it, but the trustee actually has a statutory duty to check if there is child support at many stages of the game. So the child support creditor has to be listed as what we call a priority creditor. The second you see a child support creditor, there's like a series of 4 letters that go out to the debtor attorney, the recipient, the state of Indiana, and the county prosecutor. And then at several points throughout the case, the debtor's literally just not allowed to move forward in their case unless the child support remains current. And that's the post-filing child support. If there is an arrearage at the time of filing in a Chapter 13, you can cure that over the course of the bankruptcy. So that's kind of how it would work, but it's literally, it's so important that as a Chapter 13 trustee, our case management software had a bright yellow pop-up that would be like, there's child support in this case. Like every single case, it was very, very important. And the second we heard it was behind, that's a motion to dismiss. They're done.
All right, same scenario, but now the state prosecutor does not file a proof of claim, have that in quotation marks. Father receives a discharge. Father no longer owes child support. Yellow, green. Yeah, we see a lot of yellows. It would be great if maybe we had a former state prosecutor who had, maybe a ton of experience just to give us maybe an insight on maybe some of the behind the scenes of what it looks like, at least when you were there?
Sure, thank you, Judge. So, and I haven't done it for 3 years full-time, but the issue for us would be like in a Chapter 13, the arrears that are preserved as part of the plan can be paid through the plan, but because child support is an ongoing payment, the prosecutor's office still can issue an income withholding order for the current support, and because, as many of the people in this room know, a lot of people don't actually pay their current support, they now build up a post-bankruptcy plan debt. So child support can also issue a garnishment for that additional debt that's built up that's not being covered by the trustee. And then child support has a number of administrative tools as well, passport suspension, driver's license suspension, that are not stayed by the bankruptcy, so child support can still use those tools. And then nothing to do with filing a bankruptcy can stop you from having paternity established, a new support order entered, and a new medical support order entered against you, especially for a new child that's not part of the case. So it can be where a child support case becomes a bankruptcy case because the bankruptcy trustee is covering the arrears for us, and then it's also still a current support case and even a post-bankruptcy arrears case for the child support agency. So it really requires some work between our office and the bankruptcy trustee to make sure the correct things are being paid through the right mechanism.
And this is not the prosecutor's burden to bear. It's great if they do, but they have other things to do. It is absolutely the debtor's burden to make sure that it is current and it is being paid. Say bankruptcy is a privilege, like it's kind of a right in the Constitution, but it's a privilege, not a right. And if a debtor wants to get the benefit of a Chapter 13, they also have to carry the burden of the 13, and this is just one of them.
So in your Chapter 13 case, where you have the debtor that says, I want to get my plan confirmed, I know that in order to get my Chapter 13 plan confirmed, I have to be current on my child support. Can you maybe tell us what that would look like as a Chapter 13 trustee and then also in your private practice?
From the trustee side, that would require a affidavit that they're current. If it's questionable, we might ask for some follow-up proof. And as far as my practice goes, I usually ride my clients pretty hard about this. Like they need to let me know immediately if they're behind. I usually check if there is a wage withholding order. Like it's on the pay stubs. It's very apparent, especially if it's like $347.28. It'll be there every single paycheck. If it's suddenly not there, then I know there's an issue.
All right, and then just some of the standard orders, at least in this district, are the 3 judges. The order of discharge, it's the standard national form order. So you've probably have seen this, especially maybe in some of the collection cases. And then sometimes I actually think the form is pretty useful, like the back of the form or the bottom of the form. It actually gives you a reminder of some of the things that are accepted from discharge. I know it's really hard to see, but when you do see that, it is just a good reminder if you're maybe meeting with your clients, either debtor clients or creditor clients. It does give the list of things that are commonly not discharged: taxes, student loans, domestic support obligations.
True or false? Discharge in bankruptcy is an affirmative defense under the Indiana trial rules and federal rules of civil procedure. Raise them high, everybody.
All right, we see some greens and we see some yellows. I think finally we have well, before we get to the answer, maybe a little trickier. Can anyone maybe explain why they have green or yellow?
Oh.
Hang on.
Got you. You said you wanted to run more. So I said green. Do not know if that's correct, but here's my thought process, is that it's an affirmative defense because it's something on which you would bear the burden, right, of proving. So, but whether it's actually spelled out in the rules, if it's written as an affirmative defense, I don't think it is, but that's also not an exhaustive list, right? Because some affirmative defenses are proven through case law. So that's where my thought process that it could be green, because you do have to prove it. But if you prove it, then they can't collect on it. So, but it depends probably also on the case and what you're trying to get out of the case.
We saw some yellows. Who had a yellow? It was brave, a brave yellow. Oh, there we go, yes.
So it might not be an affirmative defense because you might not have to plead it. If at any time in the proceeding, if you just show that you've had a bankruptcy and it can get rid of it, you don't have to plead it as an affirmative defense, so it may not be considered an affirmative defense. Like at any point in the proceeding, you can just say, I've had a bankruptcy, you got to stop.
Anyone else? All right, let's see the answer. Finally, a tricky one. So
everyone's right.
should have held both. And so and has anyone, I guess either in practice nor as a judge, I cannot recall, seeing this pled either in federal court or state court, but there is a difference between the Indiana trial rules and what the federal rule says. Oh yes.
I do not practice in bankruptcy, but to me, the procedural question aside, substantively, I have litigated a case where somebody failed to list an insurance policy, and therefore it was not discharged. Like the plaintiff could go after the insurance policies of the defendant who had gone through bankruptcy because, one, they had insurance policies that were not listed in the bankruptcy, and two, the defendant failed to formally dissolve after the bankruptcy. So, like, substantively, I've never seen it formally as a procedural defense, but like I've seen it litigated, and that particular defendant lost those issues because of like the substantive issues. So that's my 2 cents.
Thank you. And I think also what would be fascinating sort of procedurally is, so suppose there is a bankruptcy case, and let's say it was one of the Chapter 7 cases, and it goes really quickly, and the debtor receives the discharge order that we just saw a few slides earlier. Yes, thank you. And now in the state court case or federal case, because even though it's not an affirmative defense under the federal rules, I think you could still plead it, right? But regardless, we're at a stage where the defendant, former debtor, says, you're suing me on this contract claim. You should not be allowed to sue me on this contract claim because my debt was discharged. At that point, at least from the bankruptcy side, right, the bankruptcy case is done. There's nothing left for the bankruptcy court to do. So it would be up to, let's say it was in state court, it would be up to the state court lawyers and then the judge to decide, okay, we have this order of discharge. Was this contract claim one of the debts that was discharged in that discharge order? All right. Sally injured in a car accident 2 months ago. There's no need for her to mention this incident in her bankruptcy schedules. I think that we're going to know the answers, but we're gonna get a little harder. Right now, it's past 9 o'clock. We need some whys, true or false. Okay, everyone has false. So who can maybe explain legally why it would be problematic for Sally, poor Sally, or maybe not poor Sally, maybe Sally did it on purpose. Why is it problematic that Sally did not list or discuss her bankruptcy claim? Mr. Schudacker, thank you.
I would refer you to the Statement of Financial Affairs, where you have to answer a number of questions, and one of them relates to any possible claims you may have against a third party. So not disclosing that would be failing to live up to the requirements of filling out the proper Statement of Financial Affairs.
So to fill in the blanks of a little bit of what Mr. Scheidecker said, a bankruptcy petition is filed under penalty of perjury. That all of your assets, all of your debts, and all of your anything that the automatic stay may apply to that is known or should be known, you have to sign it under oath. And not disclosing everything is a federal crime. It is a thing like, we have made referrals to the FBI when I worked at the trustee's office. It is a serious thing. So not listing something, if she knew it, if she did it on purpose, and then she didn't list the lawsuit on purpose, yeah, that would be, we'll send it over to the U.S. Attorney's Office. Let's let them deal with it. But yes, so from a kind of functional standpoint, that's why that's an issue. From like a conceptual standpoint, like Sally doesn't get the benefit of anything that her creditors would lose out on. So it's kind of, again, equalizing the benefit with the burden of filing for bankruptcy.
And I feel like we're picking on Sally. So let's change the facts a little bit. What if poor Sally, she received something in the mail from this California law firm that said you could be a part of this class action lawsuit. She filled out the paperwork, turned it in, and honestly, the creditors are just calling. She files this bankruptcy petition, and she honestly forgot. It was completely unintentional that she forgot to list this class action lawsuit that she has in California. Does anybody have a different analysis or options of what Sally could do?
Once she remembers the possible recovery in the class action, she has a duty to file the amended Statement of Financial Affairs, including that claim in California.
What if she's ready to receive her discharge?
Well, if she's already received her discharge, and if any money comes into that, I believe she has a duty to turn it over to the bankruptcy court trustee's office, or she can't keep it unless the court allows her to.
This is very, very problematic in like medical device injury cases where there's usually a big gap between like when the cause of action accrued, like whenever the device was put in somebody's body, and like 10 or 15 years later when they know that there's an issue because like maybe there was a change in trustee, maybe those files don't even exist anymore. Like I worked on a case that was before Pacer was around. They were like, we have no idea. So the kind of in the small scale, yeah, Sally and her kind of immediate claims are an issue, but it's also kind of, it's not a problem. And so if you do any kind of med mal work, it's probably a good idea to make sure that you ask your client if they've had any bankruptcies in their past, right? Because if they have, and then they get a settlement, like the bankruptcy could come into play. It's also, if you do defense work in that respect, if a debtor doesn't disclose that they have a cause of action and they know of it. So let's say Sally is suing Paul for maliciously running her over in a crosswalk, and then she doesn't disclose the lawsuit. Well, now Paul can say, hey, you admitted in a federal pleading that you don't have a cause of action against me. I'm going to move to dismiss your case. So there's also like a defense sword available. So from a debtor's standpoint, making sure that the paperwork is as accurate as possible is extremely critical. But you can also get some information if you're involved in litigation with a debtor to use in whatever case is related.
Yeah, it was my understanding that the big problem was Sally would lose her claim altogether unless she got a waiver from the trustee that the trustee waives their claim to the asset. And unless she gets that, she's lost her claim. I thought that was a defense where you don't even have a claim anymore.
In a Chapter 7, that's accurate, yes.
Oh, okay.
Yeah.
Michael, you were shaking your head. Is that?
Employment litigation, you always ask the plaintiff if they've ever filed bankruptcy because they may have abandoned their claim by failing to schedule it. So.
Right, and there's also a very problematic case out of the Southern District of Indiana where the lead plaintiff in a class action lawsuit did not disclose the claim in her bankruptcy. And they dismissed the class action with prejudice. I believe it's called Harris v. Anthem. Don't quote me on that. It's Judge Magnus Stinson, I believe. But again, it's very problematic from, again, plaintiff's work perspective.
And what we see in our office a lot of times, let's say it is one of those medical devices, and I forgot to mention it, you'll see frequently, so the Chapter 7 trustee has already issued a no asset report, so there were no assets to give to creditors, or maybe there were assets that were distributed to creditors, but the case is completely closed, it's done, it's been done for 5 or 10 years. We frequently see the debtor will then file a motion to reopen the case. The case is reopened, they amend their schedules, they list. There's an opportunity for creditors to object. Usually there's no objection, and then the debtor can have their settlement from the medical device case.
So, terminology, we've been throwing a lot of bankruptcy jargon around. So when a debtor files for bankruptcy, there's like a packet of paperwork. There's a voluntary petition, the schedules, the statement of affairs, sometimes some other things in individual cases. The petition is the thing that pulls the trigger. It is what causes a bankruptcy to be filed. It's what makes the automatic stay spring into existence. The schedules are the lists of assets, debts, and income. The statement of affairs is a debtor's financial history going back 2 years. So those are the absolute minimum basic filings in any given consumer case. And again, that's why you get this information. You don't have to go looking for it. It's just filed automatically under oath. It has to be fully disclosed. Chapter 7 versus 13 versus 11, I think Judge Singleton touched on that. Is there anything else you want to?
No, nothing that needs to be added.
All right, so exemptions. This is where bankruptcy is federalism at work, because exemptions, property rights are state rights. Bankruptcy is a federal constitutional right. It's actually in Article 1 of the Constitution. It's not even in the Bill of Rights. It's literally right there. But again, property rights are state rights, so it's a hybrid of federal and state law at the same time. So you have to refer back to state law, and there are some wrinkles depending on like where the debtor lived so long before they filed, sometimes where real estate is located, and that tells you what a debtor is allowed to protect and how they are allowed to protect it. Judge Singleton, anything?
Yeah,
about that?
I was just going to add, if you do any creditors' rights work or debtors' work, you'll be familiar with that statute. And I guess from my point of view, for the most part, all the cases, since Indiana is one of the cases or one of the states that chose to have its own exemptions rather than the federal exemptions, I'd say 99% of the cases that we see that are Chapter 7 or Chapter 13 cases, it will be the debtor who's using Indiana exemptions. But if they if they recently moved to Indiana, or they haven't been a resident for a sufficient amount of time, sometimes we do see the federal exemptions, and then those, the applicable, I think it's 750, one of the administrative codes sort of gives the 750, and I'm blanking on the rest of it, I think it's maybe 111. But the exemption amounts, they're updated for, residence exemption, automobile exemption, those numbers do increase over time. And then the next, and we've kind of talked about it, is a proof of claim. So what you'll see, at least from the Northern District of Indiana, and briefly I'll touch on 7s and 13s. If it's a 7, the creditors who are listed on the matrix, so the debtor lists all the creditors. When the creditors will find notice that the debtor has filed a bankruptcy petition, the clerk's office will automatically, the bankruptcy clerk's office will automatically generate a notice that says Chapter 7 petition has been filed. You don't have to file a proof of claim unless you get another notice. And that's kind of consistent with most of the cases that we have. Most of the cases in the Northern District of Indiana are Chapter 7 cases. And of those Chapter 7 cases, most of those are no asset cases. But if an asset is available, let's say the debtor has a house that has a substantial amount of equity, and the trustee, the Chapter 7 trustee, intends to liquidate that house, or maybe it's a different asset that has value, then the creditors will receive a notice that says, creditors, you've got to file your proof of claim by X date. If you don't file your proof of claim, then there may be it may be likely that you won't get a distribution of the liquidated asset. And then the Chapter 13 notice, that's a little different. It will have a date for the creditors to file their proof of claim.
Yeah, and in the 13 context, it doesn't matter if you're secured. If you have a lien, you still really need to file a claim. So any attorneys out there that have attorney's liens for clients that didn't pay them, if you get a notice, don't rely on that. File your claim. So moving on, accepted from, go ahead.
And actually,
yes.
One quick point about the proof of claim. So it's a standard national form, and I thought it was always, and I guess maybe I'm being a little too technical, but it says, who's going to file the proof of claim? It could be the claimant or claimant's attorney. And I guess to me, it's always been interesting when a lawyer, and I think if you're the lawyer and you're asking for your attorney's fees, well then yes, you're the lawyer, you know what the fees are. You put your little pretty signature on the proof of claim form and send it in. It's your request for attorney fees. But sometimes it'll be the lawyer on behalf of the, maybe it's a domestic relations case, because there's like maybe a property settlement issue, or maybe it's, I think a better example that I'll use is a corporation. So the lawyer for the corporation will sign the proof of claim. And I've always thought, if I'm the lawyer, I don't think that I would sign the proof of claim. What if there ends up being an issue about what's on the proof of claim? I think that, then are you prohibiting are you going to be a witness, a material witness under the Indiana professional rules, and now you're going to be like cross-examined by another lawyer? That always seems awkward. So to me, it just seems like if I'm the lawyer, I would have my client sign it, and I would not sign the proof of claim.
Not a bad idea. Accepted from discharge are just those debts that aren't covered by the discharge injunction, your child support, student loans, criminal restitution, injuries caused by a drunk driver, or it's an intoxicated driver of any kind. There's like the statute has like 32 subsections, so there's a lot of wrinkles here. Another kind of important wrinkle is that some of them are automatic, and some of them the claimant has to file a proceeding to get a ruling. And that you really have to read the statute. If you think you're in this zone, really read the statute. Some of them are automatic, and usually those are ones that are government related. So I wouldn't necessarily assume that anything is non-dischargeable. That's the word, is non-dischargeable, just because it falls into the category, because sometimes you also have to take the affirmative step of filing what's called an adversary proceeding, which is like a lawsuit within the bankruptcy. All right. Moving on, more about DSOs. Everybody loves DSOs. It does seem like it is the most common interaction with bankruptcy. So there is a definition of what is a domestic support obligation. That's the citation. They are accepted from discharge. They're accepted from the automatic stay. And there is a higher priority than most other claims. So there is a part of the bankruptcy code that is literally called priority creditors. And it is a literal waterfall of creditors. In this class get paid before that class, get paid before the next class. And then once money runs out, then they stop getting paid, or if there is enough, it rolls down to general unsecured creditors. And DSOs are really high up. I think they're even ahead of tax debt. Like they're very high on the list. We talked about the DSOs and 13s a little bit. You have to be post-petition current to confirm a Chapter 13 plan and to get a discharge. And anytime they want to modify the plan, which happens, like you lose your job, whatever, they still have to be current then.
And so one of the benefits of a Chapter 13 that folks will sometimes choose instead of a 7, right? And it sounds like we have a great prior knowledge of bankruptcy, especially for non-bankruptcy attorneys in this room. So commonly, right, if someone's trying to save a house, right, that's when you'll see them file a Chapter 13 because they want to pay their debts over 3 to 5 years, save the house. But one of the advantages of the Chapter 13 is called a super discharge. So some things that are dischargeable in a 13 are not dischargeable in the Chapter 7, the liquidation chapter. The reason that we're mentioning domestic support obligations in the previous statute is, I say it's recent, but now it may be 2 or 3 years old. There was a Chapter 13 case that was appealed to the 7th Circuit, but the basics of it were the mediator and the parties, there was not a clear understanding of what the settlement agreement was. Was the settlement agreement more like a domestic support obligation, and therefore it's not, it wouldn't be dischargeable? Or does the settlement agreement, was it really discussing property? The reason I mention that is if you are a family law practitioner, you may want to be careful when you're crafting your language. You may want to craft it more like a DSO, use that language from the statute, because if it's more of a property settlement and a Chapter 13 debtor is successful, they play their plan over a 5 years period, even though they may owe money on the property settlement, because it's a property settlement and Chapter 13 has the super discharge. I mean, and the thought behind it's correct, right? You would rather, Congress, I think, would rather people pay their debts over a period of time than file a Chapter 7 and be done with it. So one of the advantages of that Chapter 13 is even if it's a property settlement agreement, you successfully complete your Chapter 13 plan, that property settlement may be discharged in bankruptcy.
So I've got two kind of corollaries to that. One is don't just say it is a non-dischargeable DSO, especially if it's under property equalization. Like I see that, and if I'm on the debtor side, like great, we're done. Like it doesn't matter what you call it because it is a factual analysis, not just, well, here's the word. From a trustee's perspective, so a 13 trustee is a court-appointed fiduciary, and their job is to maximize output to creditors. And a property settlement recipient is just a plain creditor, not a priority creditor. So knocking them down a class frees up money for other classes. So a 13 trustee has a fiduciary duty to review domestic support obligations, and if they are suspect, then you're not only dealing with the debtor's attorney who may want to pay his ex to keep keep them on good terms, but then you're also dealing with the trustee who's going to come in and say, no, like you're not a priority creditor, you shouldn't get paid. So it's not just that it's not just a one-on-one court relationship. There's also external parties that can come in and review that order as well. So if you are looking to make sure that it is a true domestic support obligation, make sure to kind of craft language to that effect. Child support is always child support. Like that's not a question. It's when you get into spousal support and maintenance that it is more of a gray area.
4 minutes left. Myra has a question.
Thank you. You discuss involuntary bankruptcies. When are those appropriate? Does it matter I know you mentioned the number of creditors needed. What is that number? And do you also consider the amount of debt that's owed?
It's usually, I think, 3 to 5. And it's typically appropriate where you have somebody who is very obviously mismanaging a business. If I were in the driver's seat, I usually pick a state receivership just because you can have more control over the process. But it would be that kind of situation where you have somebody that is like a creditor knows that the business is being mismanaged, usually like somebody's clearly embezzling, something like that. So again, the threshold is like the knowledge going into it is super high. Like I am not comfortable filing those. But I think it's 3 or 5. Like I'm almost positive it's 5, but I also think that there's a test in the law, and I don't know it offhand.
Yeah, I haven't seen one in the 4 years before me.
Any other questions? Okay, well, I guess we'll call it. Thank you.